Last two videos, I mentioned executor commissions and trustee commissions. But what about the situation when a person passes and we need to open an estate in surrogate's court, but there is no will? What then? Well, we have an administrator. So a person passes without a will and an estate is opened in surrogate's court, and we have an administrator. And an administrator can receive commissions just like an executor, same rates. But instead of the executor who receives his or her authority from the will, we have New York State default statute that provides for who can act on behalf of the estate as an administrator. And we have a pecking order as far as priority rights about who can petition surrogate's court to seek appointment as administrator. And we can have all sorts of twists and turns and complications at this early stage just to get somebody appointed to act on behalf of the estate. So we have this statute, and let's say we have a person who has the prior right to act, but doesn't want to act and will not sign the paperwork stating that they don't want to act. Or what if they can't be found? Or what if they're incapacitated? And then we have a situation where we have people with equal rights to act, but they're butting heads from the get-go. We could have the public administrator needing to step in at that point because of the situation. We could also have a situation where we have people with a lesser right to act, but they do not consent and agree to the person with a prior right to act, and further complications stemming from that. We could have minors and incapacitated individuals involved, again, adding to the twists and turns at this stage in the game. And then from there, moving forward, the administrator has to figure out, who am I distributing estate assets to? And instead of the will informing the person about the estate distribution, we have New York State default statute informing the person about who should receive estate assets. And again, we can have all sorts of complications. We could have individuals whose whereabouts are unknown. We could have individuals who are incapacitated, minors. We could not be able to close a class as far as being able to distribute assets. So it's very important to have an up-to-date will in place with the people who you nominate to act as executor and alternates lined up. We want to make sure that we've got the right people ready for the job. And then from there, of course, deciding what we want as far as estate distribution goes. Very important to not wait. Take some kind of action to make sure you at least have an up-to-date will in place. So this is Ruth George with Ruth P. George Law, PLLC. This video, as with any video I do put out, is for educational purposes only. It does not establish an attorney-client relationship, and I look forward to seeing you on another video.